I'd like to welcome everyone today. My name is Brian Trafford. I'm an organizer and business agent at Teamsters Local 89 in Louisville, Kentucky, and I'm a member of Teamsters for a Democratic Union. Today's call is organized by TDU. TDU is a grassroots network of Teamster members who share skills and information to build a stronger union. This legal rights workshop is a great information tool for all Teamsters, whether you're a steward, an alternate, or a rank and filer who wants to be more informed. Today, we'll be covering stewards' rights during grievance investigations, the union's right to information, and rights under the National Labor Relations Act. These educational workshops are some of the most popular things we do as TDU. If you like the information you get today and you want to keep on learning and gaining skills on how to enforce your rights on the job, I'd like you to consider coming to our convention this November in Chicago. We'll have lots more of these workshops. At this time, I'm proud to introduce to you my good friend, Brother Dave Suholtz, who will be presenting today's workshop. He's got nearly 20 years of experience as a union side attorney. He's also a husband and the father of two beautiful twin girls. Dave has worked for years with Local 89 and now with our international as counsel to the divisions of car haul and most recently cannabis. He also had a case before the U.S. Supreme Court over Title VII discrimination, and he won it. He also represents 80% of the labor movement here in the great state of Kentucky. Thank you so much, brother, for your time and for leading this workshop today. We will do a Q&A at the end, so if you have questions, please use the Q&A and we will try to get to them. Without further ado, let's get started.
Thank you, Brian. Good afternoon or good morning, my dear brothers and sisters, wherever you're patching in from. I can't thank you enough for the opportunity to be with you today on a Sunday as you spend your time arming yourself. Knowledge is power to protect our brothers and sisters in the workplace and to advance our labor movement. I want to start with this first slide by just reminding each of you as leaders of our movement in the workplace what obligations of a union steward are. In my view, you all are the backbones of our movement. You are the natural leaders in the workplace. Many of you, if not most of you, who are union stewards are democratically elected by your coworkers because of your leadership abilities. And if you haven't been elected, you've been appointed because you've been obviously the people that the local views as the ones with enough backbone to stand up and defend our contracts. Legally, as stewards, you are agents of the union. And in the coming slides, you're going to see that being an agent of the union has both rights and responsibilities that we're going to go over. You're the communicators, you're the eyes and ears of the union. You are our representatives, and you are also organizers. In many cases, you're going to be the negotiators, basically figuring out what ways we need to strengthen our contracts. You're educators in your workplaces, and you are also activists. I put in here political activists because the union movement, in my view, has three legs. We are obviously organizers in terms of constantly trying to liberate people from at-will situations so that they have collective voices through unionization. After we do that, our job is to secure strong contracts. And then finally, our job is to participate in society as a whole and be politically active so that working people have a voice. And you are political activists to educate our members in the workplace. Clearly, you're problem solvers as well. Thank you. Next slide. So the point is, as agents of the union, you have rights and responsibilities. And it's important you're taking your time today to know your rights. But as a baseline matter, a union steward's fundamental job is to study and know your contract. Most of you probably became stewards because you were the people that actually dusted off your contract and flipped through it. It is your job to familiarize yourself with your rights contained in your contract to defend your colleagues. And obviously, as the agents of the union, you are there on the shop floor to bring bigger issues back to your local unions and even your internationals when necessary. The basic rights of a steward is to represent and lead members. You do that by participating in investigatory interviews when people are in trouble. You have the ability to defend your brothers and sisters in the workplace, whether it be for disciplinary issues or because their rights contained in your contracts are be trampled on by requesting information. And you have a federal right to that information. You also, as stewards, have the right to be free from retaliation. You cannot, under federal law, be retaliated because you have chosen to step forward as the agent of the union in the workplace. And then the one of the biggest rights of a steward is the right to be treated as an equal with the boss when you are acting as a union steward. And I've underlined when acting as a union steward because that is absolutely critical. You are treated as an equal when you are in investigatory meetings, when you are in private grievance meetings with the boss, but you do not have the right and you do not have the same protections when you are out on the shop floor, because we remember, sometimes you wear your steward hat in certain situations, but also, you're also employees of the employer when you're out in public with your coworkers. Next slide. As a steward, acting as an agent of the union, as I said, you can have additional rights when you're in certain conditions and situations. I'm going to go over an important board law, a recent development in board law that reaffirmed the right that we've had for years to be protected, to act as an equal with the boss when you are in investigatory meetings and grievance situations. You do not have the right to grandstand and assert your steward rights when you're in public places on the shop floor. You need to remember that distinction. Also, remember that the basis of being a steward is carrying the collective interests of the bargaining unit. You are not protected as a steward if you're merely acting on your own individual issue or problem with the employer. You must be acting on behalf of your coworkers to assert the collective action and the protections that come along with it. You have the right to represent members in disciplinary meetings. Most of the time, the baseline right is contained in a case that's probably 50 years old at this point, called Weingarten. And that, of course, is the right of every union member to request a steward if they are in an investigatory meeting where there is a threat of discipline. However, that is the baseline right that applies to all union members under the National Labor Relations Act. Many of our contracts go a step further, including the UPS contract. We oftentimes bargain to make the employers notify affected members of their Weingarten right so that they can request your presence. You have the ability, when you are called to sit with a coworker in an investigatory meeting or a disciplinary meeting, you have the right to know the specific charges, what's being investigated. And then, of course, if there are questions or times in the investigation where a member needs to caucus with you, you have the right to pause the meeting, step out in the hall, and caucus with the member. So, first question, do members have to invoke their wine garden rights in order to receive representation during a disciplinary meeting? Though it's somewhat of a trick question, I put the depends in there because the baseline for wine garden, if there's no additional rights contained in a contract, is that a member has to invoke their right to wine garden. They're being called into an investigatory meeting and there's no other provision in the contract, that member should assert their right to union representation. They have to do that affirmatively. However, many of our Teamster contracts go a step further and they require the employer to notify members if in fact it is an investigatory meeting that could lead to discipline. The contract requires them to notify the member that they have a right to a union steward. So really it typically it's yes or depends. Next slide. So the next is the duty of fair representation. As an agent of the union, you actually, in good and in bad, can bind our unions. We, as the exclusive bargaining agents of members in an organized workplace, have a duty of fair representation, and that's basically a duty to treat members without arbitrariness, capriciousness, or because of some sort of animus or discrimination. As agents of the union, you have to abide by the duty of fair representation. You have to treat all members equally. And it is important under the duty of fair representation not to be arbitrary, to actually investigate members' grievances before making a decision whether or not they have merit. And obviously, as union stewards, you typically are not the last step in deciding whether or not to advance a grievance or not. But we have this obligation, legal obligation, to the general membership. Next slide. So our contracts are only as strong as our ability to enforce them. The primary obligation of a union steward, as I said, is knowledge of your contract. It is essential that as a union steward, you take the time to read through your contract and to, if you need clarifications, obviously that is what elected leadership or business agents of your union are for. It's important for you to be familiar with your contract, because the way we enforce our contracts is through the grievance procedure. If you're not familiar with your contract, you're not going to recognize violations of the agreement. Contracts and grievances in general aren't always just violations of the contract. We could also grieve in many situations violations of the company's own policies and procedures, many of which we don't include in our contracts. We just let the companies hang themselves with their policies and procedures. We oftentimes have the right, depending on how broadly your grievance procedure is drafted, to just basically grieve unfair treatment. Grievances can also include rights that have been enshrined through practices. Longstanding practices can be incorporated into our contracts, and we have the right to grieve changes to those practices. And finally, many grievance procedures also give us the ability to pursue rights such as Title VII freedom from discrimination for race, class, sex, national origin, sexual preferences. We often include those types of discrimination laws into our contracts, which give us the right to pursue them violations in the grievance procedure. The truth of the matter is, many important grievances end up with legal representatives like myself. And us attorneys, we get very proud when we win our arbitrations. But the truth of the matter is, the strength or weakness of the grievance begins with you. And most of the time, the victories that we enjoy are a direct result of your work and your thoughtful drafting of the grievance, your compilation of information that's going to support the grievance through your investigations, you all identifying the relevant documents and witnesses that will establish to win the grievance. Those are truly the keys to success in arbitration. And the truth is, all that we do as attorneys are present your good work. So the beginning of a grievance begins with its investigation. And obviously, that is your investigation and interview of the grievant. It is important that you bear in mind just how critical it is to ascertain the scope of your grievance and figure out exactly what information you need to win it. So when you're interviewing potential witnesses, remember the 5 W's, okay? And of course, the remedy is, how are we going to make the violation? How are we going to make the grievant whole? Next slide. Investigating the grievance. We need to begin with the relevant information. For instance, if it's a disciplinary matter, it is essential that we understand and we request personnel files for our member who's subject to discipline. What is their work record? What's their work history? Now, the time period that we have to be concerned with is going to be dictated by your contract. Oftentimes, we limit the employers and their ability to look back or present previous disciplinary records. So that's going to matter or really be specific to each of your contracts. In a disciplinary case, the seniority of the member is essential. When you're presenting the strength of your grievance, either to the union internally, be sure you know exactly who the member is, how long they've been there. It really matters for just cause, the length of time that a person has been working for the company. And then, of course, reach out and involve the member who has the grievance. What other information do they believe is relevant? Contract grievances are a little bit different, obviously. The onus is going to be more on you to know your workplace, to know the practice, to know why the specific right in the contract is important to enforce and defend. Writing the grievance. First and foremost, it is essential that you know your deadlines for filing grievances. Deadlines are always going to be specific to each of the contracts, and this is a primary responsibility of a union steward. It is also one of the biggest tripwires in terms of our duty of fair representation. Missing deadlines is the quickest way to create liability for the union. So it is essential that we understand the deadlines that are contained in our grievance procedures. But once you realize and you've determined that grievance is necessary, there's no reason to be wordy. Use brief, accurate information on your grievance forms. Stay away from inflammatory language. And of course, if you need additional information, call your union for help. There are three parts to every grievance. Obviously, it's the nature of the grievance. What were the facts that gave rise to the specific grievance? The violation in your contract. If it's specific provision, if it's a past practice, list the violation. I want to note at this point, and if you're taking notes, it is essential, if your grievance forms do not already have this language, that you always add after the violation and any other provision that may apply. Opening that door is a tried and true way to allow potentially your union attorneys, your business agents, to also pull in other relevant parts of the contract that you may not have caught the first time. Our grievance forms should have that phrase in the violation and any other provision that may apply or something to that effect. And if it doesn't, write it in. Finally, go ahead and always put down what the remedy that we're seeking for the particular grievance. Though I can tell you that the remedy, whatever you put, is not necessarily binding. We can always go beyond that. So, but it is important. That's the third part of a grievance. Next. This is a great question. True or false? Shop stewards are not allowed to solicit grievances. Well, near parity. No, it's a little more. The answer here is false. Shop stewards, your job is to actually look out for our rights under the contract. And when you see violations of the contract, it's your obligation to defend that. So not allowed to solicit grievances is a false statement. You are permitted to solicit grievances. The only caveat here is every once in a while, for whatever reason, I've seen contracts that actually prohibit this. It is a subject of bargaining, I assume, and unions are allowed to bargain away this right, as we're allowed to bargain away other rights as well. But that is a very rare contract that prohibits shop stewards from soliciting grievances. So the general rule is, yes, you are allowed to solicit grievances. And really, I see that as one of your main roles in the workplace, to defend the contract. All right. So this is one of the biggest weapons or tools that we have as a union to enforce our rights. The union has a right to information. Let's start with this next poll. Does management have to turn over information to the union? Since no one, maybe one person said false. The reality is management has to turn over information to the union. And that is true. The people who said depends, you're also correct, because the information that we request has to be relevant to terms and conditions of employment, relevant to the contract. And as long as we're making requests for information that is relevant to terms and conditions for the bargaining unit or the contract, management has an obligation to turn it over to us. And that right comes directly from the National Labor Relations Act. 8D requires an employer to bargain with the union once it's certified. And the right to bargain includes the right to relevant information. Violations of, an employer refusing to provide relevant information. Next slide. Within a reasonable period of time. Back one. There you go. refusing to provide relevant information within a reasonable period of time is a violation of the National Labor Relations Act, and really is one of the easiest unfair labor practices we're able to secure, because it's clear on its face when it happens. Note that a union can typically request information from the previous 2 years, and that's presumptively relevant under the board. You can go beyond that in certain situations if you can justify it. But you don't really have to justify requesting information from the past 2 years. There you go, John. So when you request information from the employers, it's important to build a record of that information request. So you should do it in writing. And I typically just refer generally to the National Labor Relations Act. You're requesting the following relevant information pursuant to your rights under the National Labor Relations Act, and then describe the information that you need. Initially, you don't really have to justify your reason for the information. It's probably apparent on its face why it's relevant. So I left that out. You don't have to justify in your description. The deadline, it's important that you give the employer a deadline for responding to your request. And you should not make the deadline any sooner than 3 days. Okay. The employers will take time to gather information, and we should give them a couple of days. So no sooner than 3. That's the minimum. But it's important to put the deadline in there. Now, if the employer does not respond to your request by your deadline, you're not ready for your unfair labor practice yet. It is important that you follow up with the employer, re-request the information, and refer back to your original request. I have that little example, sample language. And then give them a new deadline. If they fail or refuse to provide the information by that new deadline, you're typically ready for an unfair labor practice. And obviously, if you do that, that's when you've got to use your business agent and or the elected leadership of your local to move to that next step. But you have successfully prepped the company for an unfair labor practice at that point. Now, a couple of caveats. The employer, depending on the request for information, the employer could ask you to justify it after your first or second request. At that point, you just need to briefly state why the information is relevant to either the contract, defending the contract, or just generally to the terms and conditions of your coworkers. Next slide. What information do you have the right to request? These are examples. Accident reports, attendance records, bargaining agreements for other units, facilities, bargaining notes, customer lists, disciplinary records, employer manuals, investigatory reports, job descriptions, schedules, time cards, videotapes, wage and salary records. Couple facts. For a misconduct case, ask for the names and addresses of witnesses and descriptions of their testimony. You have the ability to actually request the information that the employer is relying on to discipline your members. And really, it's essential in order to defend your members that you find out exactly what the employer is relying on. You can ask for the names and people that the employer intends to call as witnesses for an arbitration hearing. Typically, you know who those people will be beforehand, but you have that right to request that information. You can also obviously request data on prior disciplinary actions, promotional patterns, overtime assignments. Depending on what the violation of the contract is, you can request information on unrelated people in similar circumstances to prove that people are being treated differently in your workplace. I want to take a moment to mention, oftentimes management will make the union jump through hoops when it comes to other people's personnel files. And the reality is they can't do that. The union presumptively has a right to personnel files. We do not have to get HIPAA releases to get people's personnel files. As the bargaining agents of the workplace, any relevant information to our members is available to the union and its agents. I saw one question: what if security is involved? We do have situations in workplace violence, I've seen it, where basically we should have an interactive type of process with management. If it's member on member, and there's concerns like that, typically that's elevated to the local union officers, business agents. And we basically work with the company to find out how we balance the interests of both members. But it does not in any way shift the burden to the employer to deny us information that we deem relevant to protect any of our members. Even for security reasons, the union still has the right to the information. So what information can we request? Disciplinary grievance, obviously. Personnel files of the grievant is absolutely essential. It could be personnel files of people that had, committed similar violations as the grievant. Personnel files obviously are critical to disciplinary grievances. Contract interpretation grievances require maybe different ways to establish the violation. We can request bargaining notes. Certainly, we shouldn't have to request the company's notes as much, because remember, and for those of you who have participated in negotiations, it's our job also to keep good records of negotiations and to maintain our own notes. So practically speaking, I tend to rely on our notes in a contract interpretation case way more than I would ever rely on the employer's. However, contract interpretation cases could also involve pooling company policies. We could get information, statistical data, wage and hour data. All of that type of information is available for contract interpretation cases. Next slide. So, next poll. 2 workers are involved in a fist fight. Only one of the workers is disciplined. The union requests the personnel files of both workers. The company refuses to provide the personnel file of the worker who was not disciplined. Is the union entitled to this information? Nice job. The answer is absolutely. We have a right to any personnel file that we deem necessary and relevant to analyzing whether or not the one member was unjustly disciplined. So good job. We definitely have that right to that information. Next poll. A worker has been suspended for 30 days for being out of his assigned work area. The union requests records of any disciplinary actions taken for the same offense in the last 2 years. Is the union entitled to this information? Does the company have to go and figure out for the last 2 years every person who's been suspended or disciplined for being out of their assigned work area? Nice job. Again, guys, the answer is yes. That is the beauty of this right. the employer has to gather that information for us. Do one more poll. Here we go. A worker was discharged for leaving work early and not punching out. The union believes that other workers guilty of this offense in the past received lesser penalties. The union requests the disciplinary records of other employees. The company responds that the disciplinary records of those other employees are not relevant to the present discharge. The company representative says that if the union gets permission of the other employees to review their records, the company will consider the request. Does the union need written permission? Good, Roland. I'm happy that this is similar. Do we need permission from the people we represent? The answer is no, we do not. Good job, guys. One more. The union suspects that the company has been in violation of the equalization of overtime language in the contract. It requests records of all overtime worked in the last 12 months. The company informed the union that it is not required to supply that information because there's no active grievance filed over the overtime issue. Is the union entitled to this information? The answer is yes. Now, next question. Can we get the information going back 5 years? Are we entitled to it for the past 5 years? I'm happy I put that little caveat in there. The answer is probably not. Okay. And the reason why we probably can't go back 5 years is because it's going to be really tough to say to show why that's relevant. The presumption for relevant information, the board isn't even going to question if we request going back 2 years. But if we're asking the company to go back and dig through the records for the past 5 years, we need to have a pretty good reason. And in the little facts that we gave you here, the answer is probably not. So if you guys called me up, I'd probably tell you, you got to pare back your request. Good job. So let's talk about your rights as shop stewards. Question off the bat. Can a steward swear at a manager during a grievance hearing? I'm going to let you all try to participate in this one because it's an important one. The answer is nuanced, okay? During a grievance hearing, you are the voice of the union. You are the representative of the union. And as I said in the beginning of this presentation, you are on equal footing with the employer. So if one of our grievances got passionate and cursed during the grievance meeting, this question, I guess, is swearing at a manager, calling the manager a swear word. The answer is probably you are protected. Okay. And that's the equality principle. That's exactly what Peter's just pointed out. I can caution everybody, obviously, threatening is across the line. That would not be protected. But the reality is, many of us use swear words when we get inflamed. And when you are in a private setting, acting in your role as a steward, you are going to be protected from discipline in that situation. And you'll see that the National Labor Relations Board under Trump tried to erode your rights. The last time I presented at a TDU convention, we were under some bad law and people were in trouble General Motors was the case where the Trump board basically tried to eliminate the setting specific standard that gave you broader protections. And you can see Chairman Ring, Trump's National Labor Relations Board chairman, basically his quote, "This is a long overdue change to the board's approach to profanity-laced tirades and other abusive conduct in the workplace." He did not want you to be on even footing. And again, guys, as stewards, this is where politics and our participation in the political process has concrete effects on our rights at work. This was the Trump board, and this is what we were living with. Next slide, you'll see that General Motors has been overruled. It just happened in the past couple of weeks, thankfully. And now in a case called Lion Elastomers, the board returned, you go ahead, next slide, to the setting specific protections. So when you are in a closed door setting with your employers and you're representing your members, that is a setting specific place where you are on equal footing with the employer, and losing your cool is going to be protected. I can tell you, and I want to point this out, and I mentioned this at the beginning of the presentation, that this setting specific standard basically says that when you're behind closed doors, you're protected, but if you're on the shop floor and you're cussing in the same way, you're exuberant, excited utterance, whatever it is, you could lose protection, because the board has a principle that if a union steward is grandstanding or in some way acting in a public manner that's going to diminish the authority of management, we can lose protection, and you can be disciplined in those situations. So setting specific, behind closed doors, acting as a steward, you're protected. Out in public, not as much. Next slide. I just throw in a couple other good developments that the board has recently issued. Valley Hospital basically turned back to the Obama standards, where employers cannot unilaterally stop collecting union dues on contract expirations. I threw this in here, and obviously you see the picket signs for their brothers and sisters in the UAW. This has very, very important implications for the fight that they're engaging in right now. The Trump board had kneecapped us, was going to try to starve our unions of the resources after expiration so that we couldn't effectively fight. Valley Hospital reversed that. So once again, politics have consequences. The Biden board protecting our interests. Here's another example. The power of our ability to basically engage in concerted protected activity at work by showing where we stand with union buttons. This was a case with anti-union Tesla that wanted to make people who wanted a union take their union buttons off. The Biden board again reversed a Trump precedent that allows and thus allows workers to show where they stand, either with T-shirts, buttons in the workplace. So again, politics have consequences. Finally, Tesla and next, McLaren-McComb. There we go. McLaren-McComb is an example where the Biden board is trying to protect people even when they don't have unions. And of course, Section 7 of the National Labor Relations Act applies to all employees, whether you have a union or not. And in this situation, the Biden board has protected people that are, compelled to sign severance agreements that limit their Section 7 right. They're challenging people that are forced to sign non-competes. You've heard of employers like Jimmy John's trying to lock people into low-wage jobs and making them sign non-competes. Well, the McLaren-Macomb is an example of the Biden board trying to protect even those people that have not yet organized, so that they have access to that collective concerted protected activity. Next slide. So, guys, even though you have parity as agents of the union with the employers and you have additional rights, again, you also have these responsibilities that I touched on in the beginning of the presentation. And of course, one of those paramount responsibilities is the duty of fair representation. And, you know, I would say that the duty of fair representation is just that. It's fair representation. The question is, am I treating everyone fairly? And we, as union stewards, have an obligation to all members, even members that we may perceive as guilty of offenses. We still have to afford those members due process and to spend the time to look to see if there are ways to protect people, even if we disagree with them. Next slide. The duty of fair representation requires us to process grievances in a timely manner. We can't sit on our hands. We have to take violations seriously and get on with it. When members come to us with potential violations and we file grievances, help them file grievances, whatever the case may be, it is important to communicate with those members where their grievances are. Provide them with the information that they need. If they want to participate in building their grievances, let them, you know, feel that empowerment by participating. And you all, it's your responsibility as stewards to communicate with them. The Trump board tried to weaponize that and really emphasize the importance of communicating with members about grievances, and really were looking for ways to weaponize members who wanted to sue the union. So they focus on that because it's an obvious obligation for us to communicate. So stay connected with the people who feel like they've been wronged. The union is required to provide a fair process, and that of course obligates us to take actions that are consistent and fair, not arbitrary, not just a coin toss, not based on who our friends are, who, you know, people that we've had beefs with at work. We have to set all of that aside when we're enforcing the contracts. And I know that that's a difficult thing for you to do because you're also working alongside people in the workplace, but that is a heavy responsibility that falls on union stewards. So avoiding the duty of fair representation obviously is essential. We don't have to grieve or advance every grievance. Generally speaking, I negotiate contracts that entitle all members to file grievances. I think it's a terrible practice for unions to negotiate grievance procedures that require only officials of the union to file grievances, because not filing a grievance is one of the easiest ways to breach the duty of fair representation. When you share that responsibility with all the members, obviously the members have an obligation to file their own grievance. But once a grievance is filed, obviously not every grievance has to go the distance in our grievance procedure. However, when a grievance is filed, Adam, we have to give every grievance a modicum of seriousness and investigation. Even things that look on its face as frivolous, at least interact with the member to find out what what the basis was to file the grievance. Whether or not the union advances it, that's the power of the bargaining representative. And then, of course, notify the member, ideally in writing, what the result of their grievance was. If we're deciding to pull a grievance, let's tell them, I think that writing and telling them the result of their grievance in writing probably could go beyond you to a business agent. Certainly, if a grievance, next slide, sorry. If a grievance is advancing up the steps and is right below the step to arbitrate, and then we decide not to arbitrate, it is important to, at that point, notify the member of our reason, not to arbitrate. And the union has extremely wide latitude for why it should or should not arbitrate a grievance. The union even has the power not to arbitrate a strong grievance because the union has the ability to make decisions based on financial burden that it may have, as long as it is not making, and you as stewards, as long as the union is not making a decision for an arbitrary reason, for a discriminatory reason, for a capricious reason, or because we have some sort of animus against a member, we have wide latitude to choose what grievances go and which don't. Interacting with the grievant is obviously kind of inherent to that process, and keeping them informed as a grievance is progressing. Listen, knowledge is power, and it's your ability to educate your coworkers by keeping them engaged. And then, of course, finally, and please, deadlines. It is your responsibility. It's the union's responsibility to follow the deadlines that we've agreed to in the contract. We cannot lose grievances because we're tripping on deadlines. Next slide. So actually 12:55, I think we timed this pretty darn well, Brian. I can tell you as I close this, guys, I've had the pleasure. I was invited to the TDU conference last year, and we spent a little more time. We got to go in depth about crafting different types of grievances, disciplinary, contract interpretation, and factors that we should be looking into. But I just think it's great that you all took an hour of your time today to just briefly go over the rights and responsibilities of the grievance of a union steward, and I appreciate what each of you do defending our movement and your coworkers at work. So thanks for letting me be with you this morning.
All right, thank you, Brother Dave. Before we do the Q&A, I'm going to turn it over to Sister Nicole Holliday, a UPS Teamster from Stockton, California, for a couple of announcements.
You got me okay?
Yep, we can hear you.
Okay. Hi, I'm Nicole Halliday, a 20-year UPS feeder driver out of Stockton, California. I'm also a proud member of TDU. That was some really great information. Appreciate that from Dave. I was involved with the UPS contract campaign in my building. I attended UPS Teamster United webinars, organized parking lot meetings, and we held practice pickets till the company caved to our demands. The contract campaign was huge in my local, and we couldn't have done it without the support and education from TDU. Now that we have a new contract and UPS is ramping up their discipline, we can fight back by holding them to the contract. That's why me and 10 other of our local 439 members are making our plans to attend the TDU convention. This will be my first year with the TDU convention or attending the TDU convention. If you're thinking about coming or want to come, don't hesitate to reach out to a TDU organizer for help in making your plans. TDU is always holding a UPS, is also holding a UPS grievance handling workshop on Zoom next Sunday at this same time. Hope to see you all there.
Thank you, Sister Nicole. The TDU convention is Friday, November 3rd to Sunday, the 5th in Chicago. I encourage everyone to register and attend. I've been attending for 5 years, but I learned something new every single year. We're going to send out a survey to you all after this workshop. Please fill it out. We'll send out these slides by email as well as a sample information request form and some other important resources. Now we'll take a few questions for our Q&A.
Thank you so much, Sister Nicole, Brother Brian, and Dave. You did an amazing presentation. All right, so I'm going to start with the first question from the Q&A. What if a member is obviously guilty? If a member subject to discipline is obviously guilty, what is the steward's obligation to provide a defense, and how should that be handled?
So if a member is obviously guilty, we have an obligation that the member is going to be confronted with their violation. They could be pulled into a supervisor's office. They could be immediately discharged after that. And they have a right, and we have an obligation to stand by their side at that initial process. I would also argue the best practice is to always file a grievance. Even with the most guilty member, it is important that we file a grievance just to give us the ability and time to review the circumstances. It goes back to the point, not every grievance has to be advanced. So an obviously guilty member, depending on the severity of the infraction, we might not challenge the employer's decision. But I can tell you, I have happily participated and successfully resolved many an arbitration that involved a guilty member, because there's a lot more factors that go into it than just whether or not an infraction occurred. So we still have an obligation to them, guys. And as a threshold matter, let's preserve their ability to challenge and let's review the circumstances.
Thank you. All right. We have time for maybe 2 more questions. Let's answer Vince's question. If a member does not want to file a grievance, can we file it anyways?
See, that's a great. It goes more to the question of whether or not we're going to have sufficient evidence to support the grievance. If a member is not willing to participate, doesn't want to file a grievance, that indicates they don't want to participate. But if the violation is severe enough or important enough to challenge, you absolutely have a right. Most of the time, unless your contract prohibits it, the general rule is you would have the right to grieve for the violation itself, even if the member doesn't want to file a grievance.
Okay, thank you. Here's one from the chat from Isaac. Can a grievance be filed directly against a supervisor or just against the company itself?
That's a great question, Isaac. Generally, almost in every situation, the grievance is filed against the company because the company is the one that's party to the contract. Obviously, in the description of your grievance, you could indicate that it was a particular supervisor that gave rise, led to the grievance.
Okay, great. I think we have time for a couple more. Do we have to represent a non-union employee, and how do we do that fairly?
Man,
for those in right to work states.
Yeah, I don't know who asked that, but thank you for that. Geez, you'd think I'd be more cognizant being in Kentucky now that we've switched. our duty of fair representation applies to everyone under the contract, even freeloaders. And I hate that, but it's the reality. We have an obligation to protect everybody who is covered by the contract. And I would like to add that, it's really up to us to build a culture in our workplace so that nobody feels comfortable being a freeloader, for moral reasons, whatnot. As an agent of the union, you can't lead that, but rank and file members build that culture. And in places where the culture is strong, nobody would even consider freeloading, even in a right to work place. But stewards have an obligation to represent everybody.
Okay, awesome. Let's do one more. What if a shop steward is favoring certain members, grievances are getting lost, they say that they haven't been heard after months because they're backed up? What is the right of members and what can be done?
So in that situation, I would strongly encourage a member to go beyond their shop steward. There's going to be officers of the union. There could be a business agent assigned to that workplace. But look, we're all fallible. And even stewards make mistakes, and sometimes stewards don't pay close attention to their obligations. And if that's a situation where there's favoritism, go around them, bring it to your union. We're democratic organizations for a reason. You are a part of your union, and you should go beyond them to correct that.
I would add that there's a lot that we can do to organize around issues beyond just filing grievances and letting them pile up. That kind of organizing, we have workshops around that too. We'll do a lot more, dive into a lot more of that at the TDU convention. All right, let's take one more question. And just to let everybody know, yes, slides will be available, and we'll be sending out important materials and resources by email after this workshop. All right, if a shop steward isn't available for a meeting in person, but they can call in, can the member refuse the meeting until a steward can be there in person?
Well, the employer has the obligation to provide the member with a representative under their wine garden rights. So if the member has requested it, there are occasions where if a steward is not available, you don't necessarily have the right to pick the specific steward that is going to sit with you. There have been situations where employers have satisfied their obligation by basically pulling another member into the meeting. So unfortunately, if the steward that we want is not available, oftentimes we got to use somebody else.
Okay, thank you so much for this really great information. If you have more questions, feel free to get in touch with TDU if your question hasn't been answered. We'll try to get back to you if you reach out to us. So yeah, enjoy the rest of your Sunday. Thank you. And yeah, thank you very much.